Welcome to this explainer. Today, we are unpacking a really fascinating piece of legal history, a case that perfectly demonstrates how constitutional law actually works in practice in real time. We're going to be looking at a highly significant constitutional court case, Robert Van Nell and Sam Becker versus the state. This was decided on May 28, 1998, and it revolves around a truly terrifying legal trap that the appellants found themselves caught in.
Okay, let's dive into this. Imagine for a second you're just standing in a room or maybe sitting in a vehicle, and a prohibited drug is found lying somewhere near you. Now, common sense and basic justice would tell you that the authorities need to actually prove you possessed it, right? Well, for Robert Van Nell and Sam Becker, that absolutely was not the case. They were facing a legal reality where mere proximity could automatically equal guilt. This is the core dilemma facing our appellants, and it hooks right into the heart of what a fair trial actually means.
To figure out how they got into this mess, we have to look at the specific law at the center of the controversy, the drug possession presumption. This brings us directly to Section 20 of the Drugs and Drug Trafficking Act 140 of 1992.
The law at the time literally stated, if in the prosecution of any person for an offense under this act, it is proved that any drug was found in the immediate vicinity of the accused, it shall be presumed, until the contrary is proved, that the accused was found in possession of such drug. I want you to pay special attention to those two phrases, immediate vicinity and until the contrary is proved. This isn't just legal jargon. This is essentially a loaded gun pointed at the accused. The state doesn't have to prove you own the drugs, or bought them, or even touched them. Just being nearby means the law automatically presumes you're guilty.
This terrifying statutory trap leads us to the reverse onus problem. The matter landed right on the desk of Justice McCogro at the Constitutional Court, who had to interpret exactly what this kind of trap meant for the rights of everyday citizens.
Justice McCogro explicitly defines this mechanism in her judgment, identifying Section 20 as a reverse onus. Basically, it's a legal provision requiring that facts essential to the prosecution be presumed to exist even if there's a reasonable doubt in the mind of the judge. Think about the heavy weight of that for a second. Even if the judge looking at your case isn't totally sure you actually possess those drugs, this law literally forces them to presume you did unless you can prove otherwise. So how on earth does a law like this survive in a legal system that guarantees the fundamental right to a fair trial?
Well, the short answer is it shouldn't, and that brings us to the constitutional conflict. You see, the Northern Cape High Court recognized the severe danger of this reverse onus, and they flagged Section 20 for constitutional invalidity. But here's the catch. A high court can't strike down an act of parliament on its own. They have to send it up to the Constitutional Court for final confirmation.
And this brilliantly illustrates the clash sitting right on the Constitutional Court's docket. On one hand, you have the oppressive statute, Section 20, presuming your guilt based on mere proximity. And on the other hand, opposing it, you have the supreme law of the land, Section 35(3)(h) of the 1996 Constitution. That section specifically guarantees your right to be presumed innocent, to remain silent, and not to testify during the proceedings. These two concepts just cannot coexist, so the Constitutional Court has to make the final call.
The stage is completely set. Van Nell and Becker are waiting to hear if their fundamental rights will be vindicated. The Constitutional Court must decide. But consider this completely unexpected twist in Justice McCogro's judgment. What if the court had literally just decided this exact issue?
Let's move to and see how this builds into an incredibly dramatic morning for the justice system with the Mello precedent. This brings us to another case entirely, Mello and Another v. the State, which was referred to the court at approximately the same time.
This timeline is wild, and it reveals just how fast-paced constitutional law can be. Both cases were challenging the exact same reverse onus in Section 20. As Justice McCogro notes, on the very morning of May 28, 1998, the court handed down their judgment in Mello, and they declared Section 20 invalid. So by the time they get to confirming the Van Nell and Becker case later that very same afternoon, the heavy lifting is already done. The law had just been struck down literally hours prior.
Now, what's really interesting about this slide is the technical difference between these two parallel cases. Van Nell and Becker's case was brought under the final 1996 Constitution, but the Mello case, the one that actually did the job of invalidating the law that morning, was brought under Section 1021 of the Interim Constitution, specifically Act 200 of 1993. Yet, despite this technical difference, the outcome in Mello resulted in the total invalidation of Section 20, creating a sweeping precedent for everyone else.
Because Mello struck down the law, it created a massive ripple effect for other pending cases, offering a retroactive resolution. You see, when a court invalidates a law, they have to explicitly outline who benefits from that ruling. Does it only look forward, or does it look backward to save people already caught up in the system?
So, the crucial point is how Justice Magoro applies the Mello ruling retroactively. In the Mello judgment, the court declared that the invalidation of Section 20 applies to any criminal trial meeting specific conditions. First, a verdict must have been entered after April 27, 1994. Second, an appeal or review must be pending or not yet finalized. Third, or alternatively, the time for noting an appeal has not yet expired. Justice Magoro simply points to these exact criteria and notes they perfectly cover Van Nell and Becker. They fit the criteria, so they are rescued.
And with that, our narrative arc is complete. Justice Magoro, backed by unanimous court of 9 other concurring justices, including President of the Court, Chaskelson, safely sent the matter back to the Northern Cape High Court. She explicitly stated the case is to be disposed of in accordance with the order in the case of Mello. In one fell swoop, they cleaned up a terrifying violation of the right to a fair trial.
Which leaves us with a really massive, lingering question to think about. If a single morning in a constitutional court can retroactively rescue the rights of the accused like this, how many other reverse onuses might still be hiding in the law books? How many other laws presume guilt and demand that citizens prove their own innocence? It's a profound reminder of why continuous scrutiny of our laws is absolutely vital. Thank you so much for joining me for this explainer. I'll see you next time.